safety of our interpreters. And with that, I will hand it over to our Chief Justice. Thank you so much.
Thank you very much. Should I push the button? It's on? It's on? All right, good. Good morning, everyone. Bonjour à toutes et à tous. I want to begin by welcoming members of the Parliamentary Press Gallery and everyone watching online. As every year, I'm grateful for the opportunity to speak with you today and for your continued interest in the work of the Supreme Court of Canada. I have said it often, but I believe that journalists play a crucial part in reporting on the court's work and explaining to Canadians why it matters, which is why I'm pleased to note that a representative of our court will be taking part in the upcoming Canadian Association of Journalists Conference here in Ottawa. I think it's on Friday. She will explain, well, that conference will explain what services our court provides to media to help support your coverage. Nous avons également constaté que la couverture médiatique de la Cour suprême a nettement augmenté ces derniers mois. Une partie de cette attention s'explique par certaines causes très médiatisées qui soulèvent des questions difficiles et suscitent un vif intérêt du public. Mais au-delà des décisions elles-mêmes, ce contexte met aussi en lumière le rôle essentiel que jouent les journalistes pour aider les Canadiens et les Canadiennes à comprendre le fonctionnement de leurs institutions, comment les décisions sont prises et l'importance de la primauté du droit dans la vie quotidienne. Ce rôle n'a jamais été aussi important. Dans cet esprit, je souhaiterais vous faire part de quelques réflexions sur le travail de la Cour et sur les défis à venir. La dernière année a été particulièrement marquante pour nous. En 2025, nous avons célébré le 150e anniversaire de la Cour suprême du Canada.
Not just in Ottawa, but across Canada. Our commemorative visits to many cities and towns were very successful and served as a strong reminder of the link that unites Canadians with the Supreme Court. Those visits made it possible for us to meet Canadians, to listen to them, to answer their questions, and to state once again that this court belongs to the public that it serves. As part of 150th anniversary celebrations, we also undertook to translate a number of the most important decisions handed down by the court before the Official Languages Act came into force in 1970. In October of last year, we published the first of those translations, Roncarelli versus Duplessis. So I have the pleasure of announcing that 9 other decisions have been translated as well. They're currently being revised and will soon be posted on our website. We're also taking note of the recent decision by the Federal Court on translating decisions handed down before 1970, which seem to reflect the position we've taken, that the court registrar has always taken, in fact.
Ici à Ottawa, nous avons par ailleurs accueilli un grand nombre de visiteurs à la Cour, près de 50 000 personnes ayant en effet franchi nos portes l'année dernière pour prendre part à des visites guidées ou assister à une de nos audiences.
That level of engagement speaks to a strong public interest in justice and in democratic institutions. And it speaks to a desire to better understand how these institutions work. We also marked a historic moment with the first opening of the Judicial Year ceremony held at the Supreme Court in almost 40 years. It was a meaningful occasion, both symbolically and institutionally, and I am pleased to announce that we will hold another opening of the Judicial Year ceremony on October 5th, 2026. Alongside these milestones at the court, I would also like to share some updates about the recent work of the Canadian Judicial Council, the National Judicial Institute, and the Action Committee on Modernizing Court Operations. In my role as chair of the council and of the NGI, and as co-chair of the Action Committee, I have the opportunity to see firsthand the work underway across the country to strengthen our justice system. Over the past year, the Canadian Judicial Council has updated its procedures for reviewing complaints about federally appointed judges and published its annual report on these complaints. It also released its yearly report to Canadians on judicial education and is finalizing a study on the health and the well-being of judges, which will be made public in the coming weeks. Through the National Judicial Institute, we have continued to expand judicial education, including new programming and resources on artificial intelligence, family and intimate partner violence, and judicial well-being. The NGI has also recently launched a multi-year initiative with Global Affairs Canada and the Supreme People's Court of Vietnam. This project focuses on equal access to justice, gender-responsive judicial education, and advancing leadership opportunities for women justices in Vietnam. It is a concrete example of how international cooperation can advance shared values of fairness, equality, and the rule of law. Même si la pandémie est désormais derrière nous, le Comité d'action sur la
Committee
modernisation
on Modernizing Court Operations is continuing its important work to continue improving court operations across Canada, particularly for users and especially for vulnerable and marginalized persons. Among recent initiatives, the committee published a series of documents designed to help people gain a better understanding of challenges faced by Indigenous and Black people coming before the courts, and reaffirming the importance of the social environment required for equitable administration of justice. During this press conference last year, I had not yet begun working with Justice Minister Sean Fraser, who now co-chairs the Action Committee with me. Since that time, we've had an opportunity to meet a number of times, and I'm extremely pleased about the continuing cooperation designed to modernize court activities and to improve access to justice for all Canadians. Moreover, in my role as chair of the Advisory Board on the Order of Canada, I'm happy to say that the Order is currently exploring adjustments that can be made to its processes so that it can help Canadians gain a better understanding of this prestigious distinction, as well as those who receive the honor. Recipients are recognized for contributions that have strengthened and enriched Canada in a broad range of fields and communities by highlighting their work and what they have done in their lives. We not only celebrate their remarkable impact, we also inspire other people to follow their example and to contribute to building a stronger and more united Canada.
reflect on
Tandis que nous songeons à nos réalisations,
also entering a new phase. 2 weeks ago, we held our last hearing in our historic courtroom for the foreseeable future. Our next hearings will take place in our temporary location at the West Memorial as we prepare for the long-planned rehabilitation of the historic Supreme Court building. Over the summer, the court will transition smoothly to this new place. As you can imagine, this is a complex logistical operation, but one that has been carefully planned to ensure our operations continue seamlessly. Similarly, public tours will continue all summer in our iconic building. This is an opportunity for Canadians to experience the building before it closes for rehabilitation. I would encourage people to take advantage of that opportunity. I would like also to take this opportunity to thank our staff, as well as everyone who has been involved in this transition, from Public Services and Procurement Canada, who have led the rehabilitation of the West Memorial Building, to the RCMP, who will continue to ensure the security of judges and the public in our new location. This is a particularly meaningful moment for the court, and for some, an emotional one. We are deeply grateful to everyone who is helping to ensure that this transition takes place smoothly. Notre édifice changera temporairement, mais nos responsabilités constitutionnelles, elles, demeurent les mêmes. Et je tiens à être clair à cet égard. Ce déménagement n'aura aucune incidence sur le travail judiciaire de la Cour. En parlant du travail de la Cour, en 2025,
In 2025, we handed down decisions on a vast range of areas in constitutional and criminal law, administrative law, property law. And even though there were slightly fewer decisions than the year before, we heard a higher number of appeals. That trend will continue in 2026, since we are projecting that the number of appeals will return to levels we had not observed since pre-pandemic days. This is a significant benchmark because it reflects efforts made across the country to catch up on pandemic-related backlogs. Another trend we see from our statistics for 2025 is the high number of appeals coming from unrepresented appellants who are asking for authorization. Last year, they accounted for 37% of all appeal requests put to the court. That trend seems to be increasing in 2026. That raises significant questions regarding access to justice, judicial complexity, and the pressures on people navigating a system with no legal representation. These are not abstract issues. They affect real people seeking answers and solutions through the courts. They also highlight the importance of providing clear and accessible information on how the justice system operates, particularly for those who have to face it alone.
Et puis, cette tendance fait ressortir un paradoxe.
At a time when democratic institutions are under pressure in many parts of the world, people are relying on those institutions more than ever. Our visits across Canada last year for the 150th anniversary of the court left me feeling optimistic. At this press conference a year ago, I mentioned that many of the Canadians we met were concerned about the democratic backsliding you are seeing in other parts of the world. But beyond those concerns, I also saw resolve and a strong sense of engagement across the country. Canadians, by and large, are asking the right questions, and they are demonstrating a continued belief in our institutions. And yet, that trust cannot be taken for granted. Here, too, our institutions are under pressure. As in many other jurisdictions around the world, here, too, we have seen attempts to undermine public confidence in the justice system. We have seen judges and courts sometimes portrayed as partisan actors or described as obstacles to the will of the people. Le public mérite une magistrature qui s'élève au-dessus de la politique. Une magistrature...
Politics, a non-partisan judiciary, an unpoliticized judiciary, because that is essential to the rule of law. Public confidence requires judicial independence that is both genuine and visible. In other countries, we have seen what can happen when the boundary between executive power and judicial power blurs. The consequences are serious and often difficult to reverse. Of course, criticisms and questions are part of a healthy democratic process. However, rhetorical attacks that call into question the legitimacy of courts or judges can undermine the entire justice system. At the same time, courts across the country are having to deal with a lack of resources, high workloads, and increased administrative requirements. That lack of resources leads to delays, and those delays are already being felt by Canadians dealing with the justice system. In the long term, that can erode confidence. In fact, making sure that the rule of law is respected doesn't get any easier.
Is also transforming the legal landscape at a rapid pace. Artificial intelligence is now present in the courtroom in ways both promising and problematic. Just a few years ago, hallucinated legal cases were not something we imagined. Today, they are a part of our reality. In an environment where information can be generated and shared rapidly, distinguishing fact from fiction has become more difficult and more important. New technologies offer opportunities to improve access and efficiency, but they also require courts to adapt quickly and thoughtfully. That adaptation requires investment and time, and it is necessary, again, if we want to maintain public trust in the justice system. These are indeed big challenges confronting our justice system. But as I said last year, and as I say again now, I believe in the resilience of our courts and in their unwavering commitment to upholding the rights and freedoms of all Canadians. La confiance envers nos institutions est actuellement.
Confidence in our institutions is high at present, but maintaining it requires a constant effort. Judicial independence must be respected. The courts must have sufficient resources. Public debate must remain enlightened and responsible. And Canadians must continue to see their institutions as being worthy of protection. That includes having free and impartial media. Journalists are part of our democratic institutions, and they play an essential role in helping Canadians understand those institutions. I'm fully aware of pressures that media are currently facing, as well as how important your work is in maintaining public confidence even during difficult periods. Canada's institutions work. They are resilient. They are worthy of confidence, but they will remain sound only if they are protected, respected, properly funded, and understood by the public which they serve. Thank you. I will be happy to take your questions.
Okay, thank you so much, Chief Justice. We'll start in the room. We do have a number of people today, so I'll just kindly ask that everyone try to keep their questions brief and concise, and as well with the answers to try to get to as many people as possible. So we'll start with Antoine Trepanier from La Presse.
Bonjour, Monsieur.
Good morning, Chief Justice. First of all, thank you for being here and holding this press conference once again. I know that traditionally you don't comment on cases you hear at the courts, but there is one on Quebec's secularism bill, and a decision is expected in the coming months. There will also be a provincial election. There's at least one political party that's waiting for the Supreme Court decision to take a position. Can you tell Quebecers and Canadians when and what time frame you're expecting to hand down a decision, and could it be before the provincial election? It could be. It's a broad issue. You've said that people are very interested in it. We've heard many witnesses, the longest, I believe, in the court's history. We heard witnesses over 4 days, and the court is now deliberating. I don't know when the decision will be ready. I'm not going to comment. Generally, yes, I don't, but I actually don't know. But I do hope that it will be handed down in the coming months, especially since Justice Martin did take part in the hearing, and we would like her to be able to sign the ruling. She will be resigning, or she set down her resignation date as May 30th, and there is a 6-month window for a judge who does resign to be able to remain involved in matters that they have heard. So we do hope to have it handed down in that 6-month window. Chief Justice, would you like the decision to be handed down by the court and not by a particular judge? All the decisions by the court are majority decisions, be it whether they're handed down by the court or by a specific judge. There is a majority that supports it. That's a requirement. So that's what I hope.
Thank you. We'll go to Olivia Stefanovich from the CBC.
Good morning.
Good morning.
A decade after you issued the Jordan decision, thousands of cases have been stayed across the country. You keep having to clarify the decision itself. Do you still believe it was worth it after all this time? And what is your message to provinces that continue to underfund the justice system?
Well, that's a very good question, because that's a concern. We released 2 decisions recently regarding the application of Jordan. We don't usually defend or explain the decision. They speak for themselves, but I think that one would understand that it deals with the application of this test. I still believe that Jordan is the right scheme. In other words, that although I was in dissent when the decision was rendered, now that's the law. So we have to make sure that it is applied properly across the country. But again, we still believe that the strict delays were necessary. It is unfair for a victim to wait for 5 years to testify in a criminal trial. It is unfair for the accused to wait for 5 years to have his trial or her trial. I mean, it was unfair for everybody and for society. At the same time, one stay of proceedings is one stay too many. It should never happen in Canada that criminal proceedings be stayed because of delays. Society should find the means and the ways to make sure that criminal trials will proceed within a reasonable delay, within the delay mentioned in Jordan. That's a work in progress. I think we're going in the right direction since Jordan was released. I think that all kinds of proceedings and new processes were put in place to facilitate the process of criminal trials in Canada. Many people contributed to those exercises, the judges, the civil servants, government in a way also in providing more resources, because the problem at the beginning is resources. And I think that the elected officials got the message years ago. I think that governments invested more in technology, in resources. There are still a lot to do, a lot more to do, but I think we're on the right path. So I think that the Jordan framework is still good. We had the opportunity recently to comment on Jordan in the two decisions I referred to. But I want to reassure the public that we are very mindful that there should not be a stay of proceedings, and that effort should be made by every stakeholders in the justice system that such event will never happen, or should never happen.
Thank you. And can you explain why you will not recuse yourself in the Emergencies Act case that's being brought forward by the Canadian Liberties Association, given your past comments about the convoy calling the participants, as you put it, taking the city of Ottawa hostage?
So you referred to a file which is before the court. There's an application for leave to appeal, which is pending. in the overall case before the court. And you know that we cannot comment on cases pending before the court.
Okay, thank you. Move on to Yasmine Mehdi from Radio Canada.
Bonjour, monsieur. De répondre aux questions, je vais peut-être juste clarifier la réponse à la question de mon.
Good morning, Judge. Thank you for answering questions. In Bill 21, we can expect a decision before Quebec's provincial elections. And in any case, you do believe there will be a decision within the next 6 months? Well, it could be handed down at any time from now on. But I did point out that Justice Martin was part of the panel who heard the case, and I would like to ensure that she is part of the decision, and that is indeed possible. So that's a deadline we're taking into account. It might be handed down next week or in several months.
Et dans les prochaines années, la.
And in the next few years, the court might be called upon to rule on the Clarity Act. What role do you see for the court in that debate? And do you believe that there is a point of clarifying the Clarity Act? Thank you for your questions, but we'll wait for the case to be before the court. At that time, we would hear the case and come to a ruling.
Scale from the Canadian Press.
Thank you. I wanted to ask about your comments on self-represented litigants and your concern that the number of self-represented litigants are rising. What can be done to ensure justice is served?
That's a very important question that you're asking, because it's a bit concerning, because I referred to 37% in 2025, but you have to know that within the next few weeks, within the last few weeks and months, this number, this percentage has risen to 43%. So that's why I'm saying that in 2026, my feeling is that this number will increase. So what's the reason? It's hard to identify one specific reason. There is no doubt that a question of costs and delays are possible explanations for the fact that those people will act without representation. But there might be other reasons as well. And you know, this trend has begun following the pandemic. So maybe we could find some explanations there. Eventually, studies will be produced, will provide us with some explanations. But I think it's concerning because it's a trend which is the same across the country at other levels of courts, trial levels and appeal courts. We see more and more self-represented litigants. And I don't think that the question of lack of sufficient resources and costs is the only explanation. I think it's one major explanation. But you see, it calls for additional efforts for everybody. For instance, at the Supreme Court of Canada, we've decided that we would accompany those persons. So you can imagine the time and efforts of our staff at the registry to help those people. Phone calls to help them to file the proper documents, proper authorities, and so on and so forth. So it demands a lot of efforts from our staff because we've decided that we could not simply dispose of those cases. They have the right to be considered. Unfortunately, most of those cases do not raise a legal issue of public importance. Very often, people don't know where to go, and they will file, some kind of claim at the Supreme Court, whereas it's a decision from a lower court. There's no right of appeal, or all kinds of explanations, and people don't know exactly where to go, and they will file at the Supreme Court. So we have to, unfortunately, dismiss most of those applications. There are a few which will get through, but the majority will not be successful because of that reason. So I think that additional effort should be made.
Alors je pense donc qu'il y a lieu de faire davantage d'efforts pour faire du travail pro bono notamment, peut-être pour amener le gouvernement à revoir les budgets d'aide juridique.
That we can help people to exercise their rights when they know about their rights. That calls for information and proper information. So there are many ways to help those people. I think we have to help those people. I think it's concerning that we have that percentage of self-litigants, but there's no magic solution. But we have to be mindful of that.
Also expressed concern today that some might try to politicize the courts. Perhaps you could elaborate on or provide examples of how you might see that unfolding.
Well, I was not referring essentially or only in Canada, of course, as we can see that in many other countries around us. But we're not immune. And in Canada, we have a very strong democracy. We have very strong institutions. And during our visits to 5 regions in Canada last year, we had the chance to talk to many people in different regions. And they were concerned about what they saw as the backsliding of democracy and some attacks on the judiciary and judicial independence. But still, my message was, we have to be optimistic because we have strong institutions. And what happened in Canada most recently, if you refer to some attacks or attempts to politicize the judiciary, there was a strong reaction of the chief justices in some provinces to react without engaging in discussion with specific persons. But there was strong messages given by the chief justices, and that's their responsibility. You know, chief justices in Canada, in every province, and the Chief Justice of Canada has a responsibility, not an obligation, but a responsibility to speak out about any attempts on judicial independence, attack on judicial independence, or the rule of law, l'état de droit, or any events that could jeopardize the justice system. So I like the way that the Chief Justices acted in Canada this way. We are far from a situation that we see in other countries, and I'm optimistic on that. I think that the main stakeholders in Canada understand the reason for the separation of powers, the reason for the judicial independence, for the benefit of the people. And so I think that I'm optimistic for the future in that sense.
Okay, thank you. We'll go to Chris Nardi from the National Post.
Not today, I guess. I want to dive back in quickly on the question of Ms. Stefanovich on recusal. So your comments back in the day on the Freedom Convoy, you mentioned that you felt that c'était un début d'anarchie. Vous avez parlé d'une situation et des impacts déplorables. Dans la décision que vous avez rendue, la lettre plutôt que vous avez rendue au parti, vous avez mentionné que vous ne voyez pas le lien.
In a letter, you said you saw no link between your comments and the invocation of the Emergencies Act.
J'essaye de comprendre votre raisonnement. Il y a une situation qui s'est produite à Ottawa et qui, de toute évidence, a mené à l'adoption de la loi sur les mesures d'urgence. Comment faites-vous la différence entre vos commentaires sur la situation et le fait que...
So as I mentioned to your colleague, and I just like you just mentioned as well, there is a pending litigation on that. There is a pending application for leave to appeal, which will need to be decided by the court. And that's why it would be inappropriate for me to comment on that pending application.
My other question is actually, so you mentioned the lack of judicial resources. As you well know, the government recently refused both the judicial recommendation for a change in compensation, but it also rejected the Quadrennial Compensation Commission's recommendation outright. Did you see that as a form of slap in the face to the judiciary? You've mentioned lack of compensation as a concern for attractivity to the bench. How did you respond to that as Chief Justice of the country, and did you see it as a mark of somewhat disrespect?
Well, on that issue, I have to tell you that the Association of Federal Judges in Canada has launched a legal proceeding against the decision of government not to respect the unanimous recommendation of the commission, the Quadcom. So for respect and by respect to the courts, I will not add any other comments.
Okay, thanks. We'll move to Émilie Bergeron from La Presse Canadienne.
Oui, bonjour, bonjour Monsieur le juge en chef. Désolée, un petit souci de micro. Vous avez parlé de décisions qui ont été plus suivies, peut-être que ce à quoi vous...
That had been followed more closely than what you may be accustomed to. The decision that had an impact on the Terrebonne riding that led to a by-election in Terrebonne, that drew a great deal of attention because of the fact that the government had almost a majority and could achieve a very slim one. So now, that you can step back a bit, how important was that decision to the Supreme Court? Most, if not all, decisions handed down by the Supreme Court of Canada are important by definition. It's just fact that cases that come up before us have a significant impact on Canadians. So yes, the Terrebonne case, like other cases, have a significant impact on people, on the future of society, and that's why we handed down the ruling we did. We give all cases the attention that they deserve. Last year and even the previous year, you had talked about concerns regarding security. You said they had changed for a number of judges. Are we still there? And how have security concerns changed? Well, we don't live in an ivory tower. We live in a changing environment. As for judges, I'm not aware of any specific events that have jeopardized the security of judges. It's a significant question because security is important. Now, with the move to West Memorial, I wanted to ensure that the move would be safe and that in the new building we would have the same level of security that we had or have in the current building. In a current building, we have an RCMP detachment. It's been there for many years. And I received confirmation from the RCMP that the detachment would move with us to the other building and might even be increased. It's a question of safety for us, for our employees. We have about 250 employees at the Supreme Court. And we also want to make it possible for the public to come in safely. We have an open court principle, and it's very important to maintain access to justice, not just theoretically, but physically, so that people can come into a hearing room and listen. I wanted to be certain that everything would be safe and secure. I have seen that it will be, and I would like to thank the RCMP as well as Public Works Canada, who took into account all the court's needs for the new venue.
Charles from the Toronto Star.
Merci beaucoup.
Hi, Chief Justice. On your comments about, I guess, the politicization of the courts, your role, accusations of partisanship, that sort of thing. Can you situate that for us in the context of the Alberta government's demands to have more say in federal appointments for that province?
Well, I will not discuss this specific argument or incident. But
Well, it's a referendum question. It's not just an incident. It's not just a comment. It's being put to the people. Are you talking about that kind of
I was referring to your
thing?
argument, or to your comment, rather. I don't think it would be appropriate for me to make any comments on those specifics. But in generally speaking, I think that the people of this country deserve an independent judiciary. And that means that every citizen of this country, when they enter into a courtroom, will be satisfied that the judge in front of him or her will release a decision without any pressure from any politicians, parties, lobbyists, or whatever. And that decision will be made by somebody impartial and independent. That's what I mean. And so we have to protect that. And if any stakeholders would have a different argument or proposal, I think it should not be considered. That's what I say.
I'm torn between. I'll ask you about the AI references you've put in there. What AI guardrails have you put around the court's work for your registrars, your clerks, and your judges' use of AI in research or rulings?
Yeah, we have AI is, of course, a subject of conversation in Canada and elsewhere. It's here. It will not disappear. We have to, I think, be mindful of the advantages, but also of the damages and problems that could arise from the use of AI. In terms of the legal world, there was a survey last year for 2024, I think. There were 224 incidents of fake cases raised before the courts in Canada. That's a big number. So that's the risk of using AI before the courts. The risk is increased when you consider that people without any legal background, for instance, the self-represented litigants, will usually use or often use AI to go before the court because they don't have the knowledge, the experience, the expertise, and they will put their problems in the machine and something will get out, but very often it will include fake cases, and that's a big risk. Now, at the Supreme Court level, as you know, we have a legal branch, we have good lawyers. Every judge has 3 clerks, and we read everything. Chances that we'll have fake cases submitted to us is very low, very low. I think the risk is higher at the trial court level and the appeal court level because of the phenomenon of the self-rep and because of there were incidents involving lawyers. And in that sense, I think that the law associations, the bar, law societies have a responsibility to make sure that the lawyers in Canada, as officers of the court, when they go before the court and they file documents, memorandums and briefs, should make sure to make sure that what they raise and the court case that they refer to is real. That's the responsibility, I think, of the law societies in various provinces.
Are they allowed to use it? That was my question. My
We
question
have
was judges.
so many people.
No, but judges have to rely on the professionalism of lawyers. And at the Supreme Court level, everything is filtered in a way. So chances are that we will not be caught by surprise by fake jurisprudence. But the first responsibility belongs to lawyers to make sure that they don't file fake news. We have at the court a committee on AI, and we adopted the guidelines that were determined by the CJC. So this phenomenon is so important that the CJC, the Canadian Judicial Council, has created a committee to examine this question. And the CJC has now guidelines directed to judges on the use of AI. And essentially, if I summarize the guidelines, is that AI might be used for summary of documents, but they will, and it will never be used to render judgment. It should never be used in the analysis of the facts and the law with a view to obtaining judgment. That will be always the judge who will do that work and should not be used. We adopted that guideline. The guideline is clear. It was sent to all judges in Canada. We have this special committee to modernize the courts that I co-chair with the Minister of Justice. And we also reflected on this issue of AI, and we also issued guidelines of that committee. So it's a work in progress because AI evolves so rapidly that we have to adapt and adapt to the new developments in terms of guidelines. So we're following that very closely because we're dealing with the law, and it's important that justice be rendered based on a real law, actual jurisprudence, and actual arguments. So it's a work in progress, but we are very mindful of the problematic, the advantages, but also with the major disadvantages.
Thank you. And I'm being mindful of the time here. I know you have a tight schedule, but I'd love to just get one or two more questions in if possible. We'll go to Pascal Vachon from TFO.
Oui, bonjour. Je voulais vous parler, tu avez mentionné dans votre allocution la...
I wanted to talk about your speech, the federal court decision on translations of decisions. Do you think that is a clear victory for the Supreme Court? And as a sub-question, in response to that, the Supreme Court had withdrawn some 6,000 decisions. Can you, or taken them offline, could you put them back online after this? It's an excellent question. A decision was handed down. If you read the federal court decision, you'll see that Justice Leblanc is accepting all the arguments put forward by the Supreme Court registrar. I'm taking the decision as it stands, and there's a time period for appeal, so we'll take the time needed to think about what we'll be doing. But we will wait for that appeal period to end. This case does go back a number of years, and as the Official Languages Commissioner pointed out, the Supreme Court in Canada has always been at the forefront of bilingualism. Everything is translated and well translated into both official languages, and that's been from the very start, since 1970. So the argument we put forward, we did believe that decisions from earlier in the century, in the 19th century, did not necessarily need to be translated, especially since those justices had were now deceased. I'm not going to go over the whole case. I'm trying to answer your question. It is a good decision. I'm satisfied with it. I believe it was the right decision. And out of respect for the courts, we will wait to see what happens and then come to a decision on whether we will put those decisions back on the website. But it was cautious, a cautious decision at the time. It was to make sure that we did not find ourselves in a position of having done something illegal if a judge had ruled that only bilingual decisions could be posted. The decisions still exist, but we took them off the website just so we would not find ourselves in the position of having done something illegal. We now need to decide whether the registrar will once again post those old decisions on the website again. So as part of the court's 150th anniversary, there have been a number of 150th anniversary activities, visits to the regions, activities, essay competitions. And among those activities, we decided to translate some historic decisions from earlier in the 20th century and the 19th century. But, you know, as you say, there's 6,000, so which to choose? We made the decision to refer that choice to an independent committee chaired by Justice Gascon and Austin, two former Supreme Court judges. They were also civil law deans from law schools and other notables. They came up with a roster of 24 decisions, the 24 that would need to be translated. So that was referred to the Supreme Court, and we are quietly translating them. So far, 9 have been done. There will be more, but a translation takes a lot of time, and the priority is to hear the cases referred to us and to translate decisions that need to be posted as quickly as possible. I've spoken with applicants. They haven't set aside the idea of going as high as possible. What would happen if a case on the Supreme Court were to be ruled on by the Supreme Court bench? That could happen. We will see if that hypothetical situation ever comes up. But it wouldn't be dealt with like any other case, would it? We will see if and when it happens.
I would love to just get one. Kristen, are you okay to just take one question and no follow-up, and then we can wrap it up? That'll be our last question.
Good morning, Chief Justice. So I don't have to tell you that judging is a high responsibility, high stress job, high pressure job. And I'd like to know what the Canada's federally appointed judges are telling you and the Canadian Judicial Council about their mental health and how their job-related stresses are affecting them. You did a survey at public expense from the University of Sherbrooke, and you have the results. And I'd like to know how Canada's federally appointed judges are doing vis-a-vis their mental and physical health.
Well, thank you for your question. This whole question of well-being is now discussed more and more in the legal environment. And a couple of years ago, I attended this presentation of a survey by the University of Sherbrooke, as a matter of fact, on the well-being and mental health issues within the legal community, within lawyers. And I attended this presentation. I was shocked to realize to what extent there was a serious problem in terms of anxiety, stress, mental health issues, and well-being. And I said to myself, those people are arguing cases or are involved in legal environment and knowing very well that our judges, whether it be provincial or federal judges, are under stress because of lack of judicial resources. And they have to deal with more cases, and they have to follow the strict delays and so on and so forth. So I said to myself, maybe we should try to find out what's the situation with our judges. I submitted that scenario to the CJC, and all the chief justices were in agreement with the idea of having a similar survey. So the same group proceeded with a survey with the federal judges in Canada. There was a turn of response of 66%. Now, you have to know that in those types of surveys, it's a record. It's a record percentage. It speaks volume, I would say, to the interest, first of all, of the federal judges and the extent of the importance of the issue, I think. So they developed the result, the analysis, and it's coming pretty soon. You will be one of the first ones to know about the result, as usual. I think that I don't think there will be many surprises. I think that what we've been saying for the last couple of years, that lack of resources. During some years, there were some late appointments. Now the problem has been resolved, I must say. But late appointments meant that other judges had to do the same work for 2 people. So there were increased problems in terms of well-being for the judiciary. And I just wanted to know exactly what's the status. And we'll get the status and you'll know about it. But there will not be very much surprising information.
All right,
But stay tuned.
Thank you so much. We'll have to leave it there. Thank you so much for your time this morning,
Thank you
Chief
very
Justice.
much. Thank
Appreciate
you
it.
all. Have a good day. Bonne journée à tout le monde.